The one that he was referring to over the death, that was a misdemeanor offense, 1129. So even though it was a death, it obviously wasn't something that was, intentional, that he hurt someone.
Right.
But yeah, that was the only one. I actually even questioned that one myself, but I couldn't find anything on it other than what was already in there.
But on that one, his birthday was correct.
On that one,
Yes.
no, I didn't enter that one.
You did not enter
I
that
did not
one.
enter that one.
Of the total that were entered wherever before you got to enter other ones, 41's the total number. How many did you personally enter if you just had to rough guess it?
Probably 30 or so, maybe.
So again, when he was testifying and I said, let's call it 10 in dispute, would you say that would,
That could be accurate.
whether or not that's true or not, that would be an accurate number?
Yes.
Okay. I don't have any other questions.
Montanino?
You heard Mr. Henderson testify,
Yes.
and I went through and I asked him if a lot of the crimes were his charges, and you heard him say, yes, they were.
Yes.
The only one we had a really legitimate question about was that one that you were just telling us about with the death. But you indicated that some of these charges may not have been verified, or at least were not verified by you.
Yes.
So it's possible there was a mistake somewhere or some type of mistaken identity.
There's a possibility, yes. A few of the misdemeanors.
Okay, all right. God bless you, Your Honor. You made some recommendations at the end of your pre-sentence report. You didn't quite say whether he should serve a certain amount of time in jail. You just discussed certain recommendations that would be helpful for him while on probation. Is that right?
Yes.
And hearing what you heard from Mr. Henderson today, do you still think those recommendations would be appropriate?
He can actually complete those in or out of facility.
Okay.
Yes.
Do you think he would be a decent candidate for probation?
I'm not going to answer that.
I have no further questions, Your Honor.
Anything else, General? Thank you, Ms. James. You messed up now. Any other witnesses? Any rebuttal proof from the defense? Then I'll hear you an argument. Actually, the state gets to go first on the sentencing hearing. They get to go first and they get to go last.
Alpha and Omega. As far as enhancement factors, Your Honor, I would argue that certainly number 1 would apply. He has a prior criminal history, although it's not, like I said, I only had noted 2 felonies, but that doesn't exchange the other misdemeanors, even if I think by the defendant's own testimony and by Ms. James or Officer James's testimony, we're still talking about 30 total, roughly. So I would argue that would apply. Number 3 definitely applies, at least in the aggravated assault case. It was his daughter, even by his own admission, her boyfriend, son-in-law to him, and their child that would have been a victim. Number 8, the defendant before trial and sentencing failed to comply with the conditions of the sentence involving release into the community. He was on bond. We had to revoke his bond because he continued to commit offenses. And then number 10, I would argue that that would apply. He had no hesitation about committing a crime when the risk of human life is high. When you grab a weapon, any training I've ever heard of, at least, they tell you, you better, if you're going to pull it, you better be prepared to use it. And there's only one reason to use it, and that's to defend yourself. And usually that's going to be taught to you that you end the threat, which usually means you try to kill that person. So I would argue that would apply. Number 9, maybe, but since the element of the offense includes a firearm, I'm not sure that would apply because it's part of the elements of the offense. But other than that, I think at a minimum, I think He served 6 months, at least split to serve 1, but I mean, I understand the court's position and to serve the whole 6, given what he's done in his past, and I'm glad he's sober and everything else, but you can't run away from what you've done and what that has a consequence on what you've done right now. So I'll leave it to the court's discretion.
Honor, we're here today for a sentencing hearing, which we were expecting, and it wasn't until I showed up in which all of a sudden I wasn't expecting to have a sentencing hearing. As Your Honor said, he normally doesn't get in the middle of these things, and as I was preparing my sentencing memorandum, the biggest thing that stood out to me was the same thing that stood out to the court, is the large criminal history. I remember going through everything myself. Let's count these one by one. And I think I counted 40. I must have miscounted, but obvious, it's real. And whether it's 40 or 30, it's still something that the court has a duty to protect the community. So coming in here and asking for probation from the beginning was definitely something that I had to find a reason of how do we get there. And we saw that Mr. Henderson's criminal history largely stopped in 2015, up until this recent. Put it in my sentencing memorandum. Told us today his son died in 2019. Hot and heavy again. He started committing these crimes. Through his own admission, he knew that the only way he had any chance of stopping committing crimes and even having the potential chance of living and having a decent relationship with his family was if he stopped drinking. Now, I know his bond was revoked. I wasn't his attorney at the time that it was revoked, but his arrests were July of 2023, November of 2023, and then March 4th. I don't know when this case got to circuit court, but they were there a long time before this bond was revoked, and he got sober on his own. He has the ability to support himself. He was able to sell his home through his wife while he's been in custody. He does have the ability to pay court costs and court fines. This is a gentleman that my argument before the court is we ask that he be sentenced to time served. He has been in custody since March 20th of this year.
That hearing had a little bit of everything. Judge David Wolfe presided over the sentencing of Eric Levoy Henderson, and the session pulled together testimony, cross-examination, and pointed arguments from both sides. FISR Wendy James had already confirmed that Henderson's criminal history stretched back decades, with roughly 30 convictions she personally verified, and possibly 40 when including older, disputed misdemeanors. She admitted one odd case, a misdemeanor involving a death, was difficult to verify, but overall she stood by the record. Henderson himself had testified earlier that alcohol was the root of his problems, and that he'd been sober since March 2024, a claim supported by his demeanor and consistent answers in court. The prosecution pressed hard on enhancement factors, arguing Henderson's long record alone justified aggravation. They cited his aggravated assault case, pointing out it involved his daughter, her boyfriend, and even a child present, as proof that his choices had put family members at risk. They also highlighted that he had violated bond conditions, with his bond revoked after further offenses in 2023. The prosecutor argued he had no hesitation when grabbing a firearm, stressing that training teaches you only draw if you intend to use it, a serious risk to human life. Their bottom line: Henderson should serve the full 6 years, though they conceded a split sentence with at least 1 year behind bars might be an option. The defense countered by pointing to Henderson's sobriety since March, his ability to support himself, and the fact that his criminal activity slowed after 2015, resurging only in recent years when his drinking worsened. They argued that his recognition of alcohol as the cause, his family support, and his age meant probation with conditions could be realistic. Henderson had sold his home with his wife while in custody, showing some stability, and the defense emphasized he could pay costs and fines. Judge Wolfe's role was steady and deliberate. He acknowledged Henderson's sincerity, but reminded him and the court that history couldn't be ignored. The courtroom atmosphere was serious but respectful, with Henderson calm and cooperative, the prosecution firm, and the defense candid about the uphill battle. It was less about theatrics and more about weighing decades of poor choices against a recent turn towards sobriety and accountability. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read everyone.